Thank you all for being here today for our webinar, Litigation 101, How the Court System Can Impact New York State Commercial Tobacco Control Policy. My name is, as Stephanie mentioned, Tom Pryor. I'm a staff attorney here at the Public Health Law Center. Began in February, and I work on our New York National and California teams. We're very lucky to have with us today Professor Kevin Schroth. Kevin is an associate professor with Rutgers Institute for Nicotine and Tobacco Studies and the School of Public Health, where he teaches public health law. He previously served as an attorney with the New York City Health Department, directing the tobacco control policy for the city. And during his tenure there, Kevin played a principal role in drafting and passing numerous tobacco control laws and fending off tobacco industry lawsuits. So he's a deep content expert in this area. We're very happy to have him here today and looking forward to what he has to share with us. Now, I want to begin by saying the Public Health Law Center is located at Mitchell-Hamlin School of Law in St. Paul, Minnesota, and we acknowledge that we are on the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in this area. We appreciate their ongoing stewardship, spiritual connections, and lifeways developed in the homelands upon which the law school sits. The Public Health Law Center offers free legal technical assistance to communities, public health advocates, and other partners. We also publish on commercial tobacco issues, as well as other trainings and webinars like this one. We do not, however, provide direct client representation, nor do we engage in lobbying. At the center, we prioritize equity above equality. Equity is about giving people what they need, which includes understanding barriers, circumstances, and conditions. In an equitable society, your race, gender, or sexuality would not be predictive of your health or happiness. We also address the social determinants of health, and that informs our work here at the center. And that means acknowledging that there are several factors that influence public health, including housing, education, the environment, and other social determinants. And then finally, before I jump into the content, I also want to note that today in today's presentation, if I use the term tobacco, I'm going to be referring to industrial scale commercial tobacco production, not traditional tobacco, which is used religiously, medicinally, and ceremoniously in many different cultures and tribal nations. With that, let's give a kind of overview about what we're going to cover in today's webinars. Now, we're talking about litigation and its impacts on the policymaking process. We're going to be providing an overview of our federal and state court systems, including the life cycle of a lawsuit. And then we'll take a closer look into how litigation can impact tobacco control policy through some high-level takeaways and some New York State specific examples of court areas. And our hope is that by the conclusion of the presentation, you'll have a pretty good understanding of how litigation works in practice, the nuts and bolts of it, and also what it matters and why we care about it as public health advocates. Let's begin with the general question of who makes policy in America, kind of a loaded question there. And typically our mind probably first goes towards the legislative and executive branches of government. And by legislative branch, I mean things like Congress or state legislatures, tribal councils, county boards and city councils. And these are the folks, as you know, who draft and pass laws and ordinances. And by executive branch, I mean folks like the president or governor, tribal agencies, mayors, or state and federal agencies, and even local health departments. And now those are the folks who are responsible for enforcing a law. And in doing so, they often have the opportunity to shape how policy works in practice. The most obvious example would be a federal agency that can promulgate rules that determine the nuts and bolts of how federal statutes work in the real world. An often overlooked participant in the policymaking process, however, are the courts. Now, the main power the courts have with regards to policy in America is that people can challenge how laws are enforced through litigation, which basically gives the courts the ability to go in after the fact and weigh in on laws. So if you go back to your American Civics 101 class, the legislature drafts and passes laws, the executive enforces those laws, but courts get to interpret them and in some situations basically say whether and how that law can be implemented. Now, they do that a couple of different ways. One way is that they can force a party to do or not do a certain thing. And often that's through what are called requests for injunctions or declaratory judgment. So for example, with regards to injunctions, someone suing the tobacco industry could ask for an injunction preventing it from distributing a certain product. Or the tobacco industry, when suing the government, could ask the court for an injunction preventing the government from enforcing a certain law. Now, a declaratory judgment is an order by a court defining the legal relationship between the parties and their rights. And it's typically used when a party is threatened with litigation but a lawsuit has yet to commence. So a common example might be a tobacco retailer seeking guidance from a court as to whether a law prohibiting a certain sales practice is valid before they get in trouble for violating that ordinance or law. Courts can also force a party to pay money through money damages. This is more common when an individual sues a tobacco company, for example, over something like a product defect. But technically, any party, including tobacco manufacturers or tobacco retailers, if harmed by a law, can ask for money to compensate them for the harm that they suffered. And it's also important to emphasize that these remedies, injunctions, declaratory judgment, and money damages apply to private parties and all levels of government. So in short, courts can impact policy directly by interpreting the law and declaring whether it is valid, or by ordering public or private parties to alter their behavior, but they can also impact policy indirectly by issuing damage awards, the threat of which can often alter behavior. All right, so we know a little bit of why litigation matters, but how does litigation unfold, and what does a typical lawsuit look like? Let's start at a really high level. So the typical life of a case begins in a trial court or a district court. That's where the parties build their case and eventually a judge or jury weighs in. After that, in most states, and New York State is one of them, a losing party has a right to an appeal to an intermediary court of appeals. And that's where parties basically get to say that, hey, the district court made a mistake and won't you please correct it? Now, if you lose at the intermediate court of appeals, you can then petition the state's highest court, often called a Supreme Court, to hear your case. But you typically don't have the right to be heard at that final appellate court. Most Supreme Courts in states typically accept or deny petitions based on whether they pose important legal or policy questions. Now, the court structure in New York State is fairly complex. There's a lot of different trial courts. Litigation might start, including family court and others, as this graphic created by the New York State court system shows. But for the most part, your typical public health or tobacco-based lawsuit will start at what's called the Supreme Court, which is not to be confused with the US Supreme Court. And the judges on that court are called justices, which are not to be confused with US Supreme Court justices. The Supreme Court in New York State is the trial court that has original and unlimited jurisdiction over all civil matters. Appeals from the Supreme Court go to the appellate division of the Supreme Court, and those intermediate appellate courts are divided into 4 divisions, 2 of which, the first and second departments, cover New York City and its surrounding counties. Jurists on the appellate division of the Supreme Court are also called justices, and a panel of between 4 and 5 of them will review each appeal that comes to them. Now, it takes agreement between 3 of the justices to reach a binding decision, and they're also permitted to author dissenting opinions, which basically means they disagree with the majority. Finally, appeals from the appellate division of the Supreme Court go to the also sometimes confusingly named Court of Appeals, which is the New York State's highest court. And just for good measure, the jurists who sit in the Court of Appeals are called judges, not justices. Now, there's 7 of those judges. A panel of 5 is necessary to hear each case, and it takes agreement between 4 of them to issue a binding decision. The Court of Appeals has a mostly discretionary docket, which means that they can reject appeals that come to them, but there are also some appeals that are as of right, meaning the court must accept them. And those include cases in which 2 justices at the intermediate Court of Appeals have authored dissenting opinions on a question of law, or if the appeal involves a direct and substantial question about the US Constitution. Just to complicate things a little bit, in America, we have 2 court systems that work in parallel to each other. Most cases are heard in state courts, but there's also a federal judiciary that operates in all of the 50 states as well. Now, there are strategic reasons for why a party might want to be in either state or federal court, but for today's purposes, it's sufficient to know that they both work in parallel to each other, that a question is usually decided by just one or the other, and that otherwise they function pretty similarly to one another. Now, unlike state courts, federal courts have limited jurisdiction. They can only hear cases that pose a federal question, so ones that involve challenges to federal statutes or that involve the federal Constitution. And they can also hear cases in which the litigants come from different states, so-called diversity jurisdiction. Now, in practice, a lot of tobacco control cases are heard in federal court because they involve federal questions. So, for example, if the industry brings a free speech claim under the First Amendment. This slide shows how the federal court system is laid out. And what you can see here is that presently there are 94 federal district level trial courts, and they're organized inside 13 circuits of courts of appeals, all of which sit below the US Supreme Court. New York State is in the Second Circuit Court of Appeals, pictured here. There are 6 district courts within the Second Circuit, 4 of which are in New York State. So in practice, a New York case can begin either in New York State Court or one of the 4 federal district courts within New York State. If it starts in federal district court, the parties can appeal by right to the Second Circuit Court of Appeals. And from there, you can appeal to the US Supreme Court. Now, the US Supreme Court's docket is almost completely discretionary, and each year they'll review and hold oral arguments for about 80 cases of the more than 5,000 that are filed there. It typically only grants an appeal if the case would resolve a circuit split. So if several courts of appeals have weighed in on the same question and come to different conclusions, or if there's a pressing and important legal question or an important policy matter at issue, or really all 3 of those. And then just to complicate things a little bit more, technically a case can start in New York State Court, and then after being fully litigated there, a party can appeal to the US Supreme Court if the case involves a federal question, which we just discussed. But again, the Supreme Court can decline to hear that appeal, and as we know, they almost always do. All right, so now that we know, generally speaking, how a case winds its way through the court system, let's dial down a little to discuss the life of a case in the trial court. Just to keep things simple, I'm going to focus on the federal court system, but the rules for New York State courts are pretty similarly. As mentioned, cases start in the district court, and this is where the case is built. This is where the parties will develop their facts and their legal theories and make their arguments to a judge or a jury. So I've created here a very simplified timeline of what litigation in the district court might look like, and we'll dive into each of these major events very briefly. And let's begin with the complaint. The complaint is a document that's filed into the court record by the party who's suing and asking the court for some form of relief. And when I say relief, I mean that the plaintiffs will come to the court usually seeking things like money damages as compensation for harms done to them, or asking for things like injunctive relief or declaratory relief, which we discussed earlier. Complaints can be very simple and straightforward. So all they need to do is outline the plaintiff's grievances in the form of allegations. That is, telling the other party in the court who did what to whom, and give a brief explanation of what the plaintiff is asking for as a result of that. In practice, though, lawyers will typically draft long complaints that include very detailed facts and the legal grounds for the relief that they're seeking. The complaint is filed with the court, and it's served on the defendant so that the defendant is put on notice of the claims against them, as well as the basic facts that support those claims. The next stage is that the defendant either needs to answer the complaint, which is basically saying that they agree with or dispute the various allegations made within it, or they can file what's known as a motion to dismiss. And that's basically asking the judge to dismiss either the entire case or just portions of it, because according to the defendant, there's something fatally flawed about the allegations or theories, and it would be a waste of time to litigate them. Now, a motion to dismiss is entirely based on legal arguments, not factual disputes, because at this early stage in the case, the plaintiff hasn't really had a chance to develop or prove with evidence the allegations contained within their complaint. So fairness dictates that the judge should view the facts in the complaint as true and then determine whether the plaintiff is entitled to what they're asking for based on those alleged facts. So, for example, let's say a plaintiff brings a personal injury claim against someone who ran a red light and hit them while they were crossing the street. Even assuming all the facts in the complaint are true, the case would be dismissed if the plaintiff filed the lawsuit after the statute of limitations period had run. In other words, the plaintiff would not be entitled to any relief because they filed the lawsuit too late, even if everything they said in the complaint was factually true. Generally speaking, unless there's something glaringly wrong with the complaint, like violating the statute of limitations, most cases will survive the defendant's motion to dismiss, and that's by design. You don't want judges throwing cases out before the plaintiff gets a chance to develop their facts in discovery phase of litigation and present them to the jury or judge. Now, if the case survives the motion to dismiss phase, it then moves on to discovery. And this takes up really most of the time in typical litigation, and is where a bulk of the money is spent. So we're going to focus in on this a little bit more. Discovery is basically a process by which the parties can demand information and evidence from each other, and it can cover just about anything. Parties can get access to paperwork or other physical documents, emails, voicemails, other recordings, text messages, social media posts, photographs, data, spreadsheets, pretty much anything and everything. If what's being sought is relevant to the case, then it's usually discoverable. So bear in mind here, just because something's produced in discovery doesn't necessarily mean it's going to be admissible as evidence at trial. That's a dispute for later on. During discovery, two litigants can and routinely do object to discovery requests, claiming that they're overly burdensome or are asking for irrelevant or protected information. And those disputes are frequently resolved by the court, which weighs the burdens and expense of producing the requested information against the other side's need for that information. And that sort of dispute often results in the parties drafting briefs and holding hearings in front of the court, which can itself prolong the time and costs of the discovery process. Now, there's different types of discovery requests worth knowing about. The first would be written requests, which are known as requests for admissions and interrogatories. Now, both of those require the party to answer in writing and under oath questions about the case, including questions about important facts or about who has access to information. There's also requests for documents, which is exactly what it sounds like. These would be requests for a party to produce physical or electronic documents and other information relevant to the case. And there's also depositions. Now, a deposition is an oral examination of someone about the facts of a case. And it's a bit like the cross-examinations that you might have seen in a movie, in that they're taken under oath and there's a court reporter present recording the questions and answers. But they don't take place in a courtroom. There's no judge present. And in fact, often they're conducted in a hotel or law firm conference or even over Zoom. But just about anybody within an organization who's a party to the lawsuit and who has relevant information can be deposed, and these depositions can last hours or even days. The upshot of all of this is to note that discovery is very expensive. The cost of finding and producing relevant documents alone can be immense, as well as the cost of preparing for any discovery disputes. It can also be emotionally and physically taxing for parties and witnesses, particularly if you're somebody who has to conduct and take a deposition. And finally, it can last for months or even years. Now, courtroom dramas typically gloss over discovery, mostly because it's a long, drawn-out process and not that exciting. But in reality, this is where the parties will spend a lot of their time and resources, because the information that comes out of discovery is going to make or break most cases. All right, when discovery comes to a close, one or both parties will usually move for what's called summary judgment. This is similar to the motion to dismiss, in that the parties will be asking the court for a judgment before trial on the basis that the evidence is so one-sided in their favor that there's no reason to go forward. Now, the main difference between summary judgment and the motion to dismiss is that with the motion to dismiss, you're raising only legal arguments. But at summary judgment, you can introduce facts that have been produced in discovery and submitted into the court record for the judge's consideration. So let's return to the example before, and we'll say that the plaintiff brings a personal injury lawsuit against a defendant who ran a red light. Now, the defendant might have had a dashboard camera that filmed the entire event, showing that they ran the red light and hit the plaintiff. So the plaintiff, after securing that footage through discovery, could file a motion for summary judgment, stating that given that video evidence, there's no material dispute that they deserve relief and no need to bring this case to a jury. To be clear, though, there is a high threshold for a party to win on summary judgment, and that is similar to the motion to dismiss phase because of fairness. We don't like the idea that a judge is making a decision before all of the facts are presented before the fact finder, whether that be a judge or a jury. At the final stage of a case at the trial level is, of course, the trial. And I'm not going to focus on this too much because you're probably familiar with what a trial looks like, but I will note a few things. One is that you do have the right to a jury trial, but you can waive that right and have a judge make the ruling instead. Now, there's very strategic considerations for waiving the right to a jury trial, but I mention it here because we usually think of a courtroom drama as featuring juries, but oftentimes it really is just a judge. I also will emphasize that even if the trial is short, it's still very expensive to prepare for it. You need to collect exhibits, prepare witnesses, practice your opening and closing statements, and craft a trial plan. And all of that preparation can take a week or more, even if the trial is scheduled for just one day. And then finally, I'll note that in the world of public health litigation, especially when it's industry suing government over laws and ordinances, typically the lawsuit won't get to the trial phase because often the claims are purely legal in nature and there aren't a lot of factual disputes that would survive to the trial stage. Instead, they're likely to be resolved at the motion to dismiss or summary judgment phase, or the parties would settle, which we'll talk about in just a second. As I mentioned before, if you get an unfavorable ruling in your case, either at trial or a motion to dismiss or a motion for summary judgment, you have an automatic right to appeal that decision. Now, the Court of Appeals will review the court record created and developed at the district court and make its ruling either affirming or reversing or remanding the court's decision based off of that record. They're typically not supposed to consider new factual allegations or arguments. They're not there to retry the case. They're just there to correct legal errors. Now, even though appeals are isolated to just legal questions, it can still take a really long time for a case to get through the appellate process, ranging from a few months to even a couple of years. In the Second Circuit, for example, the median time from noticing an appeal to getting the appellate court's opinion or final order is just over 10 months. And during that period, each side is going to be submitting written briefs in support of or against the lower court's ruling, and they usually set aside a day for attorneys to conduct oral arguments before the judges. Now, another important aspect of the appellate decision is that those decisions are often precedentially binding, which means that lower courts must make decisions based on the legal ruling established by the courts above it. So an appellate decision can have far-ranging impacts in the sense that the rule announced in the opinion will bind district courts that are considering similar questions in the future. I want to take a moment to talk about settlements, which I mentioned earlier, though. And that's because most cases do end up settling, often because at some point, both sides get an idea of what's probably going to happen, and they decide that it's really not worth proceeding further with the cost of litigation. And so they agree to settle the lawsuit. Typically, this is even encouraged by courts who will institute mandatory settlement conferences. Now, a settlement is basically a contract in which the plaintiff will agree to dismiss the case in exchange for something of value from the defendant, usually money or an agreement for the defendant to stop doing something or both. And the negotiations over that contract are going to be impacted by the sides' relative strengths to each other and how likely they are to win if the case proceeds to litigation. So whether and when to settle is a judgment call, and it requires weighing your chances of success based on the strength of your legal arguments, the facts of the case, the known tendencies of the judge or disposition of a jury. And it also depends upon how much you value different outcomes of potentially litigating to conclusion, including the value of getting a binding precedent from a court. So there's a lot of factors that go into the analysis that are difficult to quantify, including things like the strategic value of that precedent. And so while many cases settle, some don't. And that's because maybe the parties disagree over the relative strengths of their cases, and maybe they just disagree over the relative value of the different outcomes, including the value of litigating to a final court order. Okay, so we've talked about what a typical case looks like. But it's important to keep in mind, especially in the public health space, that there are different kinds of lawsuits that can impact public health policy, including individual and class action litigation, public interest litigation, and industry-led litigation. Before we go into this in more depth, I do want to note that PHLC has a litigation tracker on its website that includes summaries of many tobacco-related cases, which is a useful resource if you want to get a sense for the litigation landscape and a quick primer on pending cases that will impact public health policy. The first category I want to talk about is individual and class action litigation. And so these would be lawsuits initiated by private actors. And here I'm thinking about traditional civil suits brought by people against the tobacco industry, things like product liability suits or consumer fraud issues. They might be motivated by public and minded goals, but they don't necessarily have to be. You're probably familiar with what a traditional lawsuit looks like. So the hypothetical case of Doe v. Reynolds, an individual suing the defendant over the harms that they've suffered. Now, sometimes you might have multiple defendants who will join a lawsuit together against a common defendant because they've all suffered similar harms. So they still have agency and control over their own claims, but they're part of the same lawsuit just for efficiency's sake. But what happens when you have thousands of people who have near identical claims because they all suffered near identical harms? Well, you could have thousands of lawsuits, but another often better approach is to aggregate them all into what's called a class action. A class action lawsuit is a creature of the rules of civil procedure. It's a device that allows parties to aggregate their claims and to litigate them together in one lawsuit. So for efficiency's sake, instead of having 5,000 near identical lawsuits, you have one lawsuit with 5,000 plaintiffs. So one or a group of plaintiffs will be named class representatives, and they'll do your typical plaintiff things like make decisions, consult with attorneys, or sit for depositions. And everybody else is kind of a silent participant. In fact, many of them probably don't even know that the class action lawsuit is ongoing until it's successfully completed. I'm assuming many people on this webinar, including myself, have received postcards in the mail notifying us that we are potentially members of a class who have won a class award for something like a data breach case or something like that. That would be the result of a successfully litigated class action lawsuit. So there's a lot of rules and pitfalls to pursuing a class action lawsuit that we don't really have time to get into. But I do want to highlight that this is a potentially powerful device for public health policy, because the dollar amounts involved in class action lawsuits make even well-heeled companies sit up and take notice. So if one or two plaintiffs come forward with a claim for $1,000 each, that's not really going to cause much of a stir. But if you get 100,000 people together, each of which are asking for $1,000 in a class action lawsuit, that sort of exposure matters to even the largest companies in America. Of course, given how powerful these suits can be, there are a lot of rules and hurdles before you can successfully pursue them. Assuming you can satisfy those rules, though, these can be a really attractive option because you have potentially millions of people who have been harmed by commercial tobacco products in similar ways who can get justice through that class action lawsuit. The dual litigation is one great example of this sort of individual and class action litigation that we've talked about. PHLC has some publications and resources on our website describing that dual litigation, but the upshot is that because of it, Juul entered into a series of settlements covering thousands of lawsuits, including individual lawsuits and class action lawsuits, requiring Juul to pay probably in excess of $1 billion. And the sheer size of those settlements could easily bankrupt a normal company. And just as importantly, that sort of litigation has reverberating consequences because other manufacturers are going to be watching it, taking notice, and potentially changing their practices to avoid similar lawsuits in the future. Okay, so the next category I want to discuss is public interest litigation. Now, as I mentioned, individual litigation can be driven by public interest goals, but it doesn't have to be because it's controlled ultimately by private actors. So here, I'm thinking about lawsuits initiated either by public interest organizations that have explicit public interest goals, or more commonly, lawsuits initiated by the government, typically by states' attorneys general. Now, usually these would be lawsuits in which states, for example, attempt to enforce their own laws against tobacco companies. So an attorney general might sue tobacco companies for violating state consumer protection laws. And they can be for money damages, but often they ask for injunctive or declaratory relief, seeking the court to order the defendant to cease engaging in certain behavior. The archetypal case or cases here would be the lawsuits that led to the original master settlement agreement. And there's a lot of other great examples, but one I want to highlight would be the ongoing litigation in Baltimore v. Philip Morris. This is a 2022 case that's still ongoing in which the city of Baltimore sued tobacco companies over cigarette waste. And we have a summary of this case on our website, but for efficiency's sake, I'll say that Baltimore is alleging that tobacco manufacturers know that their products produce a lot of non-biodegradable waste that have been littering their city, and that the tobacco company should be held responsible for that. So in addition to asking for injunctive relief, Baltimore is asking for damages, which could be in the millions of dollars. Now, that on its own is probably not much of an impact on the tobacco companies, but if other cities could bring similar claims against the tobacco companies, the combined damages from it could be quite impactful and could disrupt their business operations. I'll end this section by talking about industry-led litigation. So as we just discussed, litigation can lead to some really great public health victories, as was the case with the master settlement agreement and the Juul litigation, but it's a double-edged sword. And industry can use litigation as a tool to slow or halt public health policy. In fact, sometimes it can feel like we are legislating in the shadow of litigation. The public health community is working to develop new, innovative ways of advancing public health goals, full well knowing that industry could sue over any one of those policies. Kevin's going to cover these sorts of cases in more depth in just a minute, but here's some things you might want to think about as he goes through his New York State examples. So we know that there's a variety of different grounds upon which industry can sue, and that litigation can derail legislation because a court can come in after the fact and tell a government that it can no longer enforce a law or an ordinance. We know that litigation can also be unpredictable, and expensive. So that even if you win, it can feel like a Pyrrhic victory. And as a result, we know from practical experience that the mere threat of litigation can stop a policy before it begins. So you might be considering a perfectly good law, one that is well within your legal and constitutional authority to enact. But sometimes a threat of litigation from the tobacco industry can encourage jurisdictions to abandon those pursuits because they don't want to bear the costs and the risks associated with it. And that's what I mean by legislating in the shadows of litigation, is that looming threat of litigation impacting our policymaking choices. So the upshot of all of this is that public health professionals should account for litigation when they consider their policy options. And that means considering things like offensive litigation to pursue your public health goals through things like class actions or public interest-led litigation. But it also means accounting for defensive litigation and the threat of being sued. Now, perhaps the most important thing you can do is to talk to your attorney and to consult them early and often throughout the policymaking process. They're going to be able to help you evaluate and minimize the risk of litigation while also helping you work through your risk tolerance and whether the policy you're considering is worth the threat of a lawsuit. By proactively managing and thinking about those risks, public health professionals can conserve resources, they can thwart the industry's litigious practices, and they can advance important public health policies. So I'm going to end there and stop sharing my slides, and I'll kick it over to Kevin to give us some examples of what this sort of litigation looks like in New York State.
Okay, good afternoon. First off, I'm going to share my screen, and I just want to compliment Tom on a really excellent presentation. And I am going to do my best to kind of highlight where some of the things he was talking about become relevant or were relevant to some of the lawsuits that I'm going to talk about. And I'm going to focus on 4 specific lawsuits that took place in the state of New York. Here's a quick list of them. Most of them took place roughly around 10 years ago. Here's a little picture. You may recognize the guy with the little red circle around his face up here behind Mayor Bloomberg. I served in the health department during the Bloomberg and the de Blasio administrations. During that time, we did pass a number of tobacco control laws, and we were involved in some of this exciting litigation. The 4 cases that I'm going to talk about are listed here. Just to spoil any suspense that might be building, we won 2 and lost 2. I think overall, tobacco control folks probably have a better than 500 record, but these, nevertheless, we're going to talk about 2 wins and 2 losses. First is the New York City flavor ban. This is a law that was the first restriction on the sale of flavored tobacco products of its kind in the United States. And as you likely know, a lot of other jurisdictions have passed flavor bans in the last decade or so. This project started quite a while ago, all the way back in 2005, long before it became an active tobacco control or tobacco advocacy issue. The law was passed in October of 2009. I mentioned the month just because it was a number of months after the national law, the federal Smoking Prevention and Tobacco or Family Smoking Prevention and Tobacco Control Act was passed in June of 2009. The tobacco industry filed a lawsuit close to the end of 2009. They did seek a preliminary injunction. The implementation of the lawsuit was delayed, but only for a relatively short while. And New York City was allowed to begin implementing the law well before the litigation came to a conclusion, which was in 2013. I just want to point out that the Tobacco Control Act, as many of you are probably very well aware, the Tobacco Control Act exempted it banned the sale, or it banned flavored cigarettes, but it had an exemption for menthol flavored cigarettes, which at the time comprised about 30% of cigarette sales. And currently menthol cigarette sales are about 37%. of the US market. So when the federal law, the TCA, exempted menthol cigarettes, but covered other flavored cigarettes, which was comprised a very small portion of the market, it really didn't accomplish much, that ban on flavored cigarettes on a federal level. When New York City was negotiating and working on its law, it saw what the federal government did there, and it decided that its law would not cover cigarettes at all. So it banned the sale of flavored tobacco products other than cigarettes. And New York City's rationale for that was that it followed the TCA's lead. The TCA, aside from banning menthol, it did contain explicit provisions that called for the creation of a TPSAC, a Tobacco Product Science and Advisory Committee. It called for them to be created and to study whether a ban on menthol cigarettes was appropriate. So based on that, New York City kind of took the position that it would wait and see what TPSAC concluded before taking further action or reconsidering that menthol ban. I don't think anybody anticipated in 2009 that 14 years would pass before either the FDA or New York City would revisit the topic, but New York City has tried to revisit it, but not successfully yet. In any event, some people may be critical of the New York City law for its decision not to cover menthol cigarettes, but what, for better or worse, these were some of the things that it wrestled with back at that time. So what did the New York City law do, and what did it not do? So as I said, it banned the sale of flavored tobacco products, and I'll focus on that, the key word there, that it focused on the sale rather than the manufacture or the distribution of flavored tobacco products. It had a couple of relatively small exceptions. I mentioned the menthol exception. That one is not small if you're thinking about menthol cigarettes. It is relatively small if you're talking about what the market for non-cigarette tobacco products looked like back in 2009. It's expanded a little bit since then. In any event, so first off, there was an exemption of a certain category of stores, and in that sense, it did not completely ban the sale of flavored tobacco products. It merely restricted them to certain outlets. But separately, it was drafted to avoid regulating the manufacturing process. So when I focus on the word sale versus manufacture, what the city was doing was it was making an intentional effort not to try to regulate what manufacturers are doing during the process of putting their cigarettes together. It didn't prohibit flavoring ingredients. It didn't address manufacturing methods or processes. It only affected the final product. And that became relevant. And it was crafted that way intentionally based on a lawsuit that it anticipated. And as Tom mentioned, as you're drafting laws and thinking about laws, it's important to try to anticipate what lawsuits might be lurking in the future so that you can try to maximize your chances of surviving a lawsuit like that. The exemption for a category of stores covered types of locations called tobacco bars. Now, a lot of different jurisdictions have some type of defined category of establishments like this. And in New York City, it was a bit of a relic of the Smoke-Free Air Act that had been passed less than 10 years earlier in the early days of the Bloomberg administration around 2001, 2002. And tobacco bars were essentially like high-end cigar bars. And when the Smoke-Free Air Act for the city was passed, it defined them in very specific terms, and it said that no new ones could be created after that law went into effect. So fast forward from 2001 or so to 2009, there were 8 tobacco bars in New York City, a city of 8 million people, and no new ones could be created. So it was a very small exception that really didn't have a public health impact, in part because only 1 out of these 8 places even sold flavored tobacco products. So sometimes exemptions, exemptions generally get a bad name, sometimes for good reason. But if you are drafting an exemption, sometimes it's a political compromise that can serve a legitimate purpose. But if you're going to do it, try to make sure that it doesn't hurt the overall purpose of the law. And this, I think, is an exemption that did not hurt the purpose of the law. So I'm going to get into the tobacco industry's lawsuit against the New York City flavor ban. And even though this took place more than a decade ago, it's still relevant today because the tobacco industry has challenged numerous flavored laws across the country, and essentially using the same legal argument that it used and lost on in New York City, and or the same argument with relatively slight variations on it. So they filed their lawsuit. It's based on federal preemption. They also had a vagueness claim. They argued that or alleged that the definition of a characterizing flavor was so vague that it was difficult to enforce. And interestingly, the tobacco industry dropped that claim voluntarily, and we suspected that they made that decision because they did not want discovery. Tom mentioned discovery and how discovery can be time-consuming and expensive. It can also force industries to open up their records and share documents that they perhaps would rather keep hidden. So they didn't pursue that claim, and we were not allowed to ask for materials or papers or documents related to what the tobacco industry knows or thinks about flavors. So they based their claim on 3 clauses in the Tobacco Control Act, known as a preservation and a preemption clause, and then the third is a savings clause. And I'm going to summarize those clauses in 5 words. The preservation clause gives, the preemption clause takes away, and the savings clause gives back. What does that all mean? Well, here's a little bit more. The preservation clause essentially says that states and local governments have a role to play in tobacco control. They're allowed to pass laws that are more stringent than some of the provisions of the Tobacco Control Act. So they can go further than the Tobacco Control Act in many circumstances. The preemption clause limits that a little bit. Even though they can go further than the federal government, they can't do something that is different from or in addition to an FDA tobacco product standard. So it's saying, yes, states can be stricter than the federal government, but when it comes to tobacco product standards, these are, and we'll talk about this a little bit, these are rules or regulations that the FDA can pass that have some impact on how products are made. They can't go further, or they can't do something different from the FDA in that specific context. And then when the savings clause comes into place or comes into play, it essentially says, remember what we said about you can be more stringent, but you can't go further than the FDA with tobacco product standards. Well, when it comes to regulating the point of sale, the preemption clause does not apply to requirements related to the sale of tobacco products. So it gives a little bit back to states and local governments in that way. So what happened in this lawsuit? Well, the court found that New York City was not preempted by federal law when it passed the city law. So it was not a requirement related to a tobacco product standard. And when I said earlier that New York City's law was a sales restriction that focused on the finished product, not the manufacturing process, those drafting decisions that were made before the lawsuit was even filed turned out to be really well conceived. The law was related, the court found the law was related to a finished product, and it didn't address the process of achieving that finished product. It didn't sort of lift up the hood and look into the process. It just looked at the final package and said, okay, if it's a characterizing flavor, if the product has a characterizing flavor, New York City retailers are not allowed to sell it. Even if it were a product standard, it would have been saved as a requirement related to the sale of a tobacco product. So again, when you're looking at those three clauses I described earlier, it was saved. That was the third clause that provide cover for New York City's law. So what's the takeaway here? It protected local authority to issue sales restrictions for certain categories of products or certain types of products. And it paved the way for similar laws. And those are the laws that I talked about earlier, laws in places like California and Massachusetts, and a lot of different towns, including some places in Minnesota and other localities. So the FDA has the ability to regulate these things like constituents and ingredients, nicotine yields, harmful and potentially harmful constituents. States, on the other hand, have the ability to issue sales restrictions, flavor restrictions, but they cannot be different from or in addition to a product standard. Moving on to another lawsuit. This one dates back a little bit. New York City passed a law. Actually, it wasn't a law. It was a regulation passed by the city's Board of Health that required a warning sign to be posted in retail stores that sold tobacco products, either at the cash register or close to where the products were displayed. Now, there is a federal law, and there was a federal law at the time, that prohibited states and local governments from imposing requirements or prohibitions with respect to the advertising or promotion of cigarettes. This clause comes in the same statute that requires Surgeon General warnings on packs of cigarettes. So it's essentially a federal law that's saying this is a federal thing. States really shouldn't be involved in doing this, and this is how it defined the parameters of what states and local governments were preempted from doing. And the rule did impose a requirement. It required a sign to be posted. It was with respect to the key question in the case was it with respect to the advertising or promotion of cigarettes? And the court held that the answer was yes. And I put this little visual here to try to help elucidate the court's thinking that the products are on display. It's all if you're standing in front of a cash register and you're looking at the cash register, you see the tobacco products and you see the warning right next to either the cash register or the tobacco product. So the court found that requirement, the sign had to be posted in that line of sight, was a key element in its analysis and its determination that the requirement was related to advertising and promotion. Moving on, there was New York City passed a 2013 law aimed at increasing tobacco prices in multiple different ways. That included a discount ban, a number of provisions that countered the illicit trade of untaxed cigarettes, a price floor, a minimum price for cigarettes and little cigars, and a requirement that cigars would have to be, except for premium cigars would have to be sold in packs of 4 or more. And I'm going to focus on the discount ban because that was the only one of these four measures that the tobacco industry sued on. And let's see what happened here. I think it's interesting that the tobacco industry did not sue on the idea that there was a problem with price floors, minimum prices for certain types of tobacco products. So in any event, in challenging the discount ban, the tobacco industry argued that the ban on discounts violated the First Amendment by preventing the tobacco industry from communicating with its legal adult customers that they were getting a bargain. And New York City countered by arguing that the law was not designed to address communication at all. It was really designed to try to regulate a certain manner of selling or a certain type of transaction that provided a discount for a product that was known to have negative health consequences. So the framing of the issue was critical to that case. We decided, New York's, and I say we because I worked there at the time, I was involved. We tried to frame this as a regulation of a type of transaction, and they tried to regulate it as a type of a restriction on speech. And the court sided with New York City on this and upheld the discount ban. And I thought it was interesting, though, that the tobacco industry, in their briefs, actually explicitly said that the city was certainly allowed to regulate prices with provisions like a price floor, but they argued unsuccessfully that the discount ban was unlawful. The last case that I wanted to talk about is a case that did not make it to that far through the process of litigation that Tom described earlier. It was a product display ban. New York City considered one, but it was never passed in city law. But Haverstraw, which is a town in the Hudson River Valley, did pass a product display ordinance that would have prohibited the visual display of cigarettes and other tobacco products at the point of sale. It would have required them to be hidden behind cabinet or a curtain or something to that effect. The picture that I have here is actually a picture from Canada, which has a product display law, national product display law. There's a number of other countries that have them, but they don't have First Amendment restrictions that are as challenging as the US First Amendment. So Haverstraw adopted its law in April of 2012. The tobacco industry sued, and based on the threat of that lawsuit and with an understanding of some of the challenges in succeeding in that lawsuit, Haverstraw rescinded its ordinance voluntarily before going forward with litigation. And it would have been a challenging lawsuit. I see it's already 1:54. I'm going to try to go quickly. But one of the reasons that Haverstraw likely agreed to rescind its lawsuit was not just that they would have to fight the tobacco industry, and this would have pitted a relatively small town against the resources of the tobacco industry, which would have been a difficult challenge, but also because of the prospects of losing. It could have set a negative precedent that could have set back some tobacco industry or tobacco control interests for years to come. So I'll briefly describe why this would have been a challenging lawsuit. The government can restrict speech, but it needs a very good reason. And the terms under which the government can restrict speech are established by some Supreme Court precedent. There's a 4-part test known as the Central Hudson test. The first 2 parts wouldn't have been very controversial here. The speech that came into play was not unlawful. The government has a significant interest in regulating speech, like banning the display of harmful products that are also addictive. So it would have probably satisfied that second part of the test, significant government interest of saving lives. But where it becomes more difficult is whether the government has sufficient evidence to show that the law would advance its interest, but also that it would restrict no more speech than necessary. And that's one of the really tricky parts of this central Hudson test. So you have to show that the law would work, but that it can't be overly burdensome in securing its effect. So I'm going to, in my last slide, just outline some of the arguments that could have been made, but I'm going to cut myself short here, just in case there's any questions. Thank you.
We'll give folks, a couple more seconds to think about whether they have any questions. And in the meantime, I just want to emphasize again, how happy and thankful we are that Kevin was able to join us today and present on those cases. And I think they really neatly display some of the things that we've been talking about. Sometimes tobacco sues and they lose. And I think that's something for public health advocates to remember, that just because tobacco is suing or threatening to sue does not mean they have a meritorious claim. It does not mean that you should necessarily abandon your policy. It does mean, however, you should probably talk to your attorney to get a better sense of the merits of their case and what those threats really mean for you. Looking at this comment in the chat here. And I also, as somebody noted in the chat, we do have some fact sheets coming out on litigation and some other kind of common grounds for tobacco-led litigation, for example, on commercial free speech, which Kevin touched on at the end there. So we're trying to provide educational resources that can hopefully guide you and guide you with the conversations that you have with your attorneys as you're crafting this policy.
And I'll just point out also that when I was in the trenches, when I was at New York City, thinking about and crafting laws like this, we did reach out to places like the Public Health Law Center. And it's really useful to do that because it's not that hard. And you can kind of imagine a scenario where folks are working hard within a relatively small group of people to try to pass a law, and you have a common purpose and a common goal, and you think everything's great. But if you don't reach out and get an outside perspective, sometimes you might miss something. And just having an outsider who has a fair amount of experience in something like this, have them say, well, did you think about this? Did you think about that? I mean, sometimes the answer will be like, yes, we thought about it, and this is why we did this. But no, we didn't think about the second thing you mentioned. Can you talk to us more about that? So it is extremely helpful to get outside of your little bubble, I think. I don't mean that in a derogatory way. I mean it in a positive way. Sometimes it's positive. It's really helpful to get out of your circle of people who have been dedicated and working on something to get outside perspectives.
Well, thanks very much. If folks do have questions, please don't hesitate to reach out to the center. Our contact information should be listed there. And I believe, as maybe in some of the correspondence about this webinar. I want to thank you again for joining us today and talking about these important issues. As somebody mentioned in one of the comments of the panelists, it is disheartening that industry has a lot of resources and can bring those to bear on litigation. But if we work together, if we plan ahead, we can craft good public health laws that will be better protected from industry lawsuits. So thanks all for joining this conversation and continuing that conversation going forward about how we can best do that.